Looking for Mr. Sims. Are you here, sir?
Yes, ma'am.
Where are you? Are you in jail?
Yes, ma'am.
All right, so Mr. Lampson's client, Michael Sims, does appear in person in custody. And are there any announcements, Mr. Lampson?
Your Honor, we're here on the state's motion to revoke probation. I had given some documents to the county attorney, as well as for the chamber's copy to Your Honor, detailing the efforts that Mr. Sims has been making while being supervised in Oklahoma. The main violation basically is that he failed to get the scram device installed, which was a specific condition of his probation. And we do not deny that he did. It was financially based. Basically, he couldn't afford it. He was being tested for alcohol. I supplied those records to Mr. Lett. He's been negative. He wasn't drinking. He wasn't violating any other conditions of his probation, but he did fail to get that monitoring. So we would ask, he has now been in custody for some time. We're asking that the court consider that a sanction and then reinstate his probation, but modify it so that it does not require that scram device. He'll continue to be tested in Oklahoma.
All right, we also have present CSO Tony Bauer. And so I understand the defendant is going to waive hearing and stipulate that he violated his probation or not, Mr. Lampson.
We'll stipulate that we violated in the fact that we did not obtain the scram device as required.
Okay. And Mr. Bauer, that seems to be a large focus of the motion. Is that correct?
That is correct.
Yeah, it's not just scram. He didn't do his 90 days of house arrest. He was supposed to have 48 hours and the rest of the 88 days on house arrest for his 90-day sanction. Because go ahead.
He did complete that part.
Yeah, he completed his house arrest.
He completed the house arrest. There was some back and forth on monitoring. There were some monitoring issues, but he did complete the house arrest. He did not do the scram. Sorry, I did not mean to cut you off, Ms. Gillette.
That's all right.
Okay, so, and I was up to speed on this at one point, but okay. So, Mr. Bauer, is Oklahoma wanting to close their supervision on him?
Our supervision through Oklahoma has already been closed. Once a warrant is issued and he has picked up on it, that case has to be closed out. And that has already been done. That case has already been closed out through Oklahoma.
Now, but he still lives in Oklahoma, is that right?
Correct.
So tell me if I follow one of the recommendations that I think I just heard of giving basically credit for the time he served as a sanction and reinstate him, is that workable under the interstate compact laws?
So if you was to accept the sanction and reinstate his probation, then we will have to do a new interstate compact agreement, and he will have to stay in Kansas until that agreement can be completed and accepted by Oklahoma. And then if they approve it and accept it, then he can go to Oklahoma at that point. But until they approve it, he cannot go back to Oklahoma until that's approved.
And if they won't approve it, then he just has to stay in Kansas. Is that right?
Correct.
Even if before the transfer happens, he can come back to Kansas and report. He can report by phone. He can do whatever the court orders, but he can go back to Oklahoma and he can live there and he can work.
Your Honor.
I have people do that all the time.
Well, hold
Your
on.
Honor,
I look at Mr. Bauer as kind of the authority on interstate compact. So, Mr. Bauer?
We went through this the last time we had a revocation hearing on him with whether or not he could go back. He is a mandatory transfer. He cannot leave the state of Kansas until Oklahoma accepts him. If he was a discretionary, then yes, he could. But he is a mandatory. So we have to have approval before he can go to that state.
What I'm saying is don't interstate compact him. Keep him supervised in Kansas. Give him the ability to travel outside of the state.
Your Honor, again, this
That's
is what we
done
discussed
all
the
the
last
time.
time. He
Come on,
is a
Mr. Lamb.
mandatory transfer. We don't get the option to not transfer. You can order that we don't transfer, but by federal law, we have to do a transfer with him. We went through this at his last hearing.
Okay.
Wasn't
So,
aware this was a federal case.
well, but you know how the federal government controls a lot of things that we do. We can't, for instance, give a CDL holder diversion, or we're going to be in trouble with the federal government. So it may not be a federal case, but we are kind of obligated by some of their rules, such as the interstate compact in this case. Okay. Now, Ms. Gillette, do you want to jump in on this matter?
You know, Judge, frankly, he's having to do Oklahoma's drug court. That's why we did the situation we did last time, is to give him a chance on drug court. Part of that included the scram. The court ordered that. The court ordered house arrest and 12 months probation extension from his last hearing, which was June 13th of 25. At that time, he said there any violations. There's the one here. He needed to start his 90 days on Sunday. So, you know, he's been given chances. He was sentenced and January 23rd of 24 was when we sentenced him. And then we got him back for revocation in June of 25. This is his second revocation. At some point, a defendant has to take responsibility for his choices and his actions. And we didn't put too many extra requirements on him other than the house arrest and the scram, because the major issue in this case has been continued alcohol consumption, and him needing treatment. It's up to him to accept those things and to take responsibility for it. So at this point, the scram didn't happen. Frequent UA testing happened through Oklahoma. That's not something we get records of during the time that things are happening. They have been provided to me after the fact by Mr. Lamson. It appears that the UAs were happening, that's 10 days, that's 4 days. I don't know if it's random. Looks like it's about once a week, is how often his UAs are. Sometimes it's sooner than that. And I have been provided copies of the UAs from the Oklahoma 10th Judicial District, Osage County. They start June 3rd of 2025, go to July in this packet. I also was given a treatment update, and he had gone to treatment with the Osage Nation Health System. There's some more that go up till September when he was arrested herein. So he did have UAs, and they were negative, including alcohol. It's not a replacement necessarily for the scram, because it's not a daily mode of monitoring. But it does appear that he had been doing treatment and being UA'd down there. Is it 100%? No, it's not. And the ball is in his court as to whether or not he's going to comply with what's required by our court. Although he is a resident of Oklahoma, he came to Kansas when he got in trouble. He got in trouble here. And he has to comply with both what our rules are and what Oklahoma's rules are. And when you have an interstate compact, it's a compact. And so you have to dot every I and cross every T when you go across the state line. So for what I believe, if he gets a sanction and he's allowed to go back on probation. This is his second time up. And I know that the court doesn't like second times up. If he's allowed to go back to drug court, I expect that there's not any blips down there, that he will comply with all of his treatment there, and that he'll understand that on a third time up, I would be asking for him to serve his underlying sentence. If the court wants to put a sanction with a couple of extra days so that he can work with Mr. Bauer on paperwork and trying to get a transfer back to Oklahoma, that's something that could be also thought about. He was arrested in this matter. I have down. Deputy, do you know what day he came into custody here?
September 22nd.
And did he have any time from before he came here?
I'd have to have him go pull it up. I can do that.
Well, keep in mind, Ms. Gillette, as my notes indicate from the last hearing, he also picked up a DUI in Oklahoma after this, but he had something going on in Sumner, Osage, and/or Washington counties.
He does. I have a copy of information from him getting in trouble down there as well. So I have that information.
He was not, Ms. Gillette, he was not arrested in Oklahoma and transported up. They advised him of this warrant. He came up and turned himself in. And when he came and turned himself in, he also brought me a copy of the UAs as well.
And how many of those UAs were dirty?
None.
None.
None, okay.
None of them. He was good on every UA he had.
But-
So
Did they do those during the hearings where he had drug court, so he knew they were going to do a UA?
They are random. I
They're
have to-
random, but are they random only when you go into court? You just don't know which court hearings are going to do
No,
it?
ma'am. I have to call in every morning and they will call my color. And it was twice a week and I'm phased up to phase 3 in drug court, which makes it once a week now. But I'm also going to 3 AA meetings, 3 counseling meetings, and last week would have been my 7th month.
the dates fluctuate between 4 days to 7 days apart, Your Honor, from what I can tell on them.
Your Honor, if you would like, I can bring you the copy I have.
I'll just take, I got the information I needed. Thank you though, Mr. Bowden. Well, when I pull up his record on Odyssey, the most recent are the 2 23s in Greenwood County. And then he's got something, it looks like in Cherokee, but that's speeding. Then he's got a DUI in 2020. So if he has the other ones, they're not showing. What do you show on Kansas for Osage and Washington County, Mr. Bauer or Ms. Gillette, if you show anything on those for DUI?
Your Honor, I believe those 2 are out of Oklahoma.
Oh, those are Oklahoma counties, okay. And those have both been since we put him on probation down there?
Correct.
All right, anything further from the state, Ms. Gillette?
No, Your Honor, that's all I have.
Mr. Lamson, anything further?
I just think that if Michael were given another shot, I think he could be successful. It sounds like the program that he's working through Oklahoma has been beneficial to him, that he's been doing it, that he's been clean, he's been sober. If the scram monitoring was a requirement that this court thought was necessary, I believe he could find a way to do that financially. I think it would create a hardship for his family, but I believe he would do that in order to reunite with them and be able to go back to work. So that's what we would ask the court to do, Your Honor. And he has family in Kansas if he had to stay here until the transfer could be completed. I don't think that would be an issue as long as he was able to travel to Oklahoma maybe for work.
Doesn't he have a small child in Oklahoma?
Yes, ma'am.
He does, Your Honor.
How old is that child? Remind me.
I got a 4-year-old and a 3-year-old.
And which of those two children was the child that gave rise to the aggravated endangering by having that child in the car while you were convicted of DUI?
The 3-year-old.
3-year-old, okay. Do they live with you now?
The 3-year-old does. The 4-year-old lives with his mother.
Well, is there anything else anyone else has to say? Mr. Bauer, anything you want to say?
Your Honor, I would just say I have not had any specific issues with Mr. Sims. He has stayed in contact with me. When he's known about the warrants, he has came and turned himself in. He's been compliant with drug court down there. He did not get the scram unit in, but he did discuss with me on a couple occasions. He was having some financial issues with trying to get scram set up. So I know that that was a concern he was trying to work through. I don't know that reinstating him to a probation and trying to do interstate compact and everything is going to be the best option. It's definitely an option. My suggestion would be, and I know the court probably does not like the idea, given he's picked up 2 new DUIs while on probation. My suggestion would be is do the sanction and close this case. He's been on for almost 2 years in this case. But close this case so we don't have to continue to deal with the interstate compact part of it. And he can deal with his stuff in Oklahoma. He's got 2 felony DUIs down there pending with his drug court stuff. If he messes that up, he's going to have probably some significant time to serve for them in that before we'd probably be able to get him back up here to really address any real concerns up here. Because any further violations probably is going to be violations on both Oklahoma and Kansas, absent us having some special conditions that Oklahoma doesn't have. So my request would be to give him some kind of a sanction or something. He's the only supporter for his family, so he definitely needs to be taking care of his family, but give him some kind of a sanction and just close our case and let him deal with his Oklahoma stuff, where he's probably going to have more significant time to serve if he messes those up.
All right, well, that sounds, Mr. Bauer's recommendation sounds very similar to what we did, I believe it was June 10th of 2025 at the first show cause hearing. After he'd gotten a new 3rd DUI in June of 24 in Oklahoma and was put in their drug court program and was reportedly doing well. The defendant at that hearing stipulated to violating his probation by purchasing, possessing, or using alcoholic beverages or illegal drugs and failing to report all changes in residence, telephone number, and employment and any law enforcement contact immediately or the next day. At that hearing, his probation was revoked. The parties jointly recommended to the court, though, that instead of outright revocation, that he be placed on 90 days of house arrest with electronic monitoring and work release. But then it took him some time to do the work release or the house arrest. So did he actually ever do that house arrest? He did do that, you said a while ago?
90 days total. Well, there was 48 hours here, 88 days house arrest.
I did 2 48 hours here and then my 90 days house arrest.
Okay, but even that didn't keep him from violating his probation again. Here we go again. And I'm not sure. So my thought on it at this point is that he's already tried what Mr. Bauer is suggesting, which makes sense since he is an Oklahoma resident and they are dealing with him. And I remember that there was a lot of tugging at the heartstrings about the child and supporting the family. And I'm all for a man supporting a family that he chooses to have. But I'm not all for a guy continuing to get DUIs, one with his child in the car, any one of which could cause someone else to have a child in the car and lose a whole family, or an individual could get hurt in a way that would change their lives forever, if not killed. So At this time, because the defendant has had this many DUIs while on probation and has not yet concluded his drug court program down there, I'm going to revoke his probation and remand him to the custody of the sheriff to serve the balance of his sentence. Of course, he will be entitled to credit for time served. Deputy, do you know how much time he has to serve? Or how much credit he has?
I do not off the top of my head, man.
Judge, he had 105 days before his arrest. He was arrested 9/22. He has 15 more additional days. I have him having 120 days.
Well, I want the jail to confirm that. I'll give him credit for all the time he served. I have to, that's the law. But he just keeps getting DUIs, and the next one he may not come out of so lucky, or the people around him may not. But I've basically tried to work with him. So that will be the order of the court. And at this time, it'll be the balance of his sentence, which was 13 months, an extra 30 days added because of the child in the car when he was sentenced January of 2024. So there's nothing further. We're in recess on this hearing. Thank you all.
Thank you, Your Honor.
You're welcome. Thank you, sir.
I think we have Mr. Barnes left too.
All right, let's see.